Good morning, gentlemen. I'm sorry I'm slightly early.
Good morning, my lady. We're awaiting the court. We've got nowhere else to go.
Morning, everybody. I see we have Lady Justice Asplin, and do we have Lord Justice Green?
Yes.
Thank you. Perhaps Natalie will call the case.
Yep. In the matter of Phones for You in Administration v EE Ltd and others, hearing day 2.
Mr. McLean.
Good morning, my lords and my lady. I hope you can hear me clearly and see me as clearly as the video technology allows. My lords and my lady, when we finished yesterday, I was going to consider some questions posed to me by the learned master of the rolls, and I'll come to those in a moment. And that was, of course, whether a mobile phone may itself be a document within the meaning of the CPR rules, and I'm going to cover that.
And Mr. McLean, when you do cover it, the court has had discussions outside.
Yes.
And we were thinking about what the position is in relation to documents held on the cloud.
Yes. I'm going to attempt to give you the benefit of some submissions as far as I'm able within the limits of my technological experience and knowledge. And I do emphasize that when I come to explain the position as I see it, it's based on what I've been told by those with more experience, technological experience than I, in relation to such matters. But I'm going to come to that in a moment, my lord, after I've addressed you on 2 further matters. Now, one of the issues which arises in these cases is what can a court do as a matter of case management in relation to disclosure, where there is a mixed source or repository for documents. Now, in our submission, it won't surprise the court to hear that we say that's an intensely fact-sensitive question, and in the circumstance, and that's a matter for the learned judge, having considered all the relevant issues in the case. For example, what are the allegations which are being made in the case, what's at stake in the case, etc., etc. The list of factors which the learned judge may take into account are without limit in our submission. Now, Part 31.7 requires a reasonable search to be conducted when we're talking about standard disclosure. I don't believe 31.7 is in the bundles, and I apologise for that. It is in the white book at page, I think it's 10. Sorry, I've lost the reference. It's page 1017. And what that says is when giving standard disclosure, a party is required to make a reasonable search, calling for documents falling within 31.6b or c. The concept there is a reasonable search. And as I've said, what is or is not a reasonable search is an intensely fact-sensitive question for the learned judge to determine. And I also mentioned to the court yesterday Part 31.58, which is, I think, in the electronic bundle for my lord who's following this. That's H3 20.4, page 2, and it's also on page 1012 of volume 1 of the white book. And if we could have up on the Opus screen that document. And there the court sees, I hope, subparagraph 8 of at any point give directions as to how disclosure is given, and in particular what searches will be undertaken, of where, for what, in respect to which time periods, and by whom, and the extent of any search for electronically stored documents. Now, in our submission, that provision is concerned primarily with the practical, mechanical steps which are necessary to put a party in the position of stating that a document exists. And as your Lordship, the Master of the Rolls, discussed with Mr. Hopkins yesterday, maybe it was Lord Justice Green, I don't recall, disclosing documents involves, formally anyway, stating that a document exists. That's what disclosure is under the rules. And as my Lord Justice Green observed yesterday, paragraph 15 of the learned judge's order, which is in Core Bundle 1 at tab 17, page 185, Bundle H1, tab 17, page 7, electronically, that paragraph is concerned with preparatory steps to the defendants giving disclosure of documents which are within their control and just so happen to be stored in their employees' or agents' mobile devices or in the repository of their email. So that is a preparatory step towards giving disclosure. And what it would lead to in the event that any documents were identified by the e-disclosure provider is that those documents would be then passed to solicitors for the relevant defendant. They would be reviewed for the test for standard disclosure and then formally disclosed. So I respectfully agree with Lord Justice Green that what paragraph 15 is concerned with is not actually compelling disclosure. It is concerned with the practical question when you're confronted with a mixed source, which may be a mixed, in this case, a mixed electronic source, but the question will arise, it may arise in relation to physical repositories as much as electronic repositories, and one shouldn't get too held up or too bogged down by the fact that these are electronic devices. The court is in a position to order a party to take practical steps for the purposes of giving effect to its disclosure obligations, and the learned judge in our submission has done no more than that. Now, if I may speak more generally, obviously, when the court considers what steps, preparatory steps, ought to be taken by a party in relation to giving disclosure, the judge may have to consider concerns of privacy. And concerns of privacy will form part of the multifactorial assessment as to what reasonably is required by way of searches. Now, if I may give an example at one end of the spectrum, which is not this case, but may illustrate the principle. Suppose that there is a claim for breach of contract. Obviously, all breaches of contract are different, but let's describe it as a plain vanilla case where Company A says that Company B failed to supply a product which it had contractually promised to deliver. There are no allegations of dishonesty. There are no allegations of covert conduct. In that kind of case, the court, in considering what is reasonable, may require strong reasons to order that any reasonable search be extended to the personal mobile devices or email accounts of the individual employees of the contracting parties. On the face of it, there might be every reason to believe that the search of work emails, correspondence, and databases would, at least in the first instance, be sufficient. If one changes the facts slightly and says that it turns out that the parties know, or it is discovered, that one of the key custodians in relation to this claim for breach of contract, in fact, mostly used his personal email account for communications in relation to the relevant contract, the picture would change. And the question for the court in considering what is reasonable would be this. Should I make an order which facilitates an attempt to conduct a review over those personal email accounts? Now, as with all questions close evaluation of the relevant considerations. In some circumstances, it might well be sufficient for the custodian himself, who it has shown has conducted all his or some of his work-related communications through his email, his own personal account, to conduct the search himself and to produce any documents which he discovers as a result of conducting such a search. In another case, it might be appropriate to suggest that a third party conduct the filtering exercise, but it all depends on the circumstances of the case. Now, your lordships and your ladyship have seen that in paragraph 47 of the learned judge's judgment, he referred to the notorious fact that in cases of alleged covert collusion, it is well known that individuals who attempt to engage in such conduct may use personal email devices and may use personal phones in order to avoid being caught. And the learned judge had in front of him a real-life example in connection with this particular case, where, as I've said, EE, who is not a party to these applications, has admitted that an approach was made to it by a representative of the Telefonica defendants. They used, and Mr. Swanty made a recording of that approach, it is said, on his personal iPad. Now, we're not able to get access to the personal iPad because that has apparently disappeared or been misplaced. But it shows that every case has to be considered on its merits as to what is or is not reasonable. And in this particular case, the learned judge determined that in the first instance, and you'll recollect that he said in the first instance, what I propose to do is to order these defendants simply to make requests of a limited number of custodians, to ask whether they are willing to make devices available for the purposes of conducting searches over them, to identify documents which are work-related. Now, that is not to say, my lord and my lords and my lady, that it would not be possible to envisage circumstances where the discretionary approach that the judge took trespassed over the boundary into jurisdictional error. And that's where the Galadari case comes in, which is relied upon by the defendants. Now, I showed the court yesterday, and I don't intend to take you back to it unless you wish me to do so, to the judgment of Mr. Justice Morritt as he then was. But as I submitted yesterday, when one reads his judgment, as cited by Lord Justice Glidewell in the Court of Appeal, it's perfectly clear that what Mr. Justice Morritt sought to do then was to make an order which required the bringing within the control of a party for the purposes of giving disclosure of the documents newly brought within his control under the ambit of disclosure. And the Court of Appeal said that isn't permitted. Order 24, as then was, required a party to give disclosure of documents in its possession, custody, or power. And it did not empower the court to make some form of order which brought within the control of a party documents which were not already there. And that was the jurisdictional error that was made in that case. But when one is concerned here, as one is, with a mixed source which contains personal documents which are not relevant to the issues in the action, and also work-related communications, which it's accepted the defendants have a right to call for or to inspect, then the court has to adopt a more nuanced approach. And I can see and I can accept that if appropriate protections were not put in place, then it is possible that an order that a request be made, which is then fulfilled by the addressee of the request, which results in material coming within the possession or the control of the person requesting it, that could result in error, effectively, in the disclosure obligations of the person making the request being extended, but it doesn't do so in this case. And that's the jurisdictional objection which runs through most of the submissions which have been addressed to you by the defendants. And one sees that clearly in Orange's skeleton in paragraph 44.4, because they say disclosure to the IT provider, and the same point would arise, my lords and my lady, if the IT provider were replaced by an independent solicitor. They say disclosure to the IT provider is disclosure to the defendants, and that's wrong. That's simply not right. And it's not right because of the mechanism learned judge put in place. And you have to ask yourself, let's suppose that a custodian to whom a polite letter of request is addressed says yes and hands over the device for the purposes of searching to the third-party IT disclosure provider. Now, it is plain as a pikestaff in my submission that if the phone is held by the IT provider, it is not within the physical possession of the defendant. So one's looking to see whether provision to a third party like an IT provider results in the phone, which for these purposes I'm not treating as a document, I'm simply treating as a repository, a source of documents, whether that physical document is within the physical possession of the party to the litigation. The answer to that is no, obviously not. Next question would then be, well, if it's not in its physical possession, leaving aside any questions of contractual entitlement to the device, which we're not concerned with here, would that step result in the defendant being entitled to call for or to inspect itself the material on the device without limit? In other words, to look at the device for the work-related material and also to look at the personal material. And the answer to that is obviously not. And the reason the answer to that is obviously not, it resides in the careful undertaking mechanism which the learned judge put in place. And one can see this in Core Bundle 1, tab 17. Page 10, so that's H1 1710 or Core Bundle 1, tab 17, page 188. Now, this sets out a form of undertaking which is to be given by the e-disclosure providers to the court. And they are undertaking, as you see in paragraphs 2, 3, and 4, essentially to search the devices which are voluntarily provided to them, if any, for the purposes of identifying documents which are work-related documents, and having identified those, to pass those work-related documents to the solicitors for the defendants, who will then be in a position to review those for the purposes of disclosure. But they will undertake to the court, if any device is provided, to disclose, not to disclose any content other than which is responsive to the search. There's an undertaking to the court. Now, how does that fit within Order 31, CPR 31, Rule 8? Well, it's perfectly obvious in my submission that, as I've said, the physical document is not within the possession of the defendants. It's also equally clear in my submission that the defendants could not call for the documents to be provided to them, nor for the right to inspect those documents, because that would be contrary to the undertakings which have been given to the court by the independent IT provider. So there is no question of these documents coming within the control, the personal documents coming within the control of the defendants, and thereby enlarging by accident their existing disclosure obligations, which already cover the documents, the work-related documents, illustration of this situation, my lords and my lady, in the case of HTC and Nokia, which is in the authorities bar. And I wonder if we could.
I mean, is this in any way contested? I mean, nobody, I think, is suggesting that the defendants under this mechanism get control of the devices or the personal material.
Well, I think it is contested, my lords and my lady, because you have a blanket submission that what is wrong jurisdictionally with the order is it results in control being acquired by the defendants over material which is not otherwise in their control. And it says that's a violation.
I mean, I see Mr. Scannell shaking his head, and it seems to me that couldn't be the argument. I think the argument is that the breach of privacy is putting the personal devices in the hands of an IT consultant who may or may not be trustworthy and may or may not adhere to the undertakings that he's given.
Yeah.
I mean, it's perfectly obvious that an undertaking in the court to the court that says you won't do something means you mustn't do it, and that the court can't regard you as having done it or being likely to break it. But that's not really the point that's being made against you. I mean, well, Mr. McLean, for my part, I'm particularly, I mean, I understand all your submissions about the balance and the kind of case and the circumstances of this case and the discretion the judge exercised. I mean, those are what they are. Obviously, we have to weigh them into account on the discretion and proportionality issue.
Yes.
But I am particularly concerned, personally,
yes,
about the jurisdictional question.
Well,
because if you're right about the jurisdictional question, then it has very, as I see it, potentially far-reaching consequences for disclosure generally, and for what devices. I mean, everybody in this country, nearly, lots of people, certainly in business life, has one or more personal devices. And I think we can assume that many of them, mistakenly or deliberately, use those devices for their business purposes.
yes,
And therefore, there are if we were to hold that these devices were within the control of the businesses, the relevant businesses, for the purposes of disclosure, which seems to me that has tremendous ramifications, potentially.
forgive me,
I understand all you say about the control on the ramifications by virtue of the need for a reasonable search, the court's power to control what searches are made, etc., etc. But I'm very keen to have your submissions on the jurisdictional question before you get to that.
Well, what I'm having...
In Nokia doesn't really, I mean, let's look at it quickly anyway, because you've mentioned it, but I mean, I don't think it answers any of those questions.
Well, it depends, my lord, what you mean by the jurisdictional question. And I had been proceeding on the basis of the jurisdictional question, which was raised against me, was the proposition that and one can see this from the skeleton arguments of the defendants, that simply acceding to the request would extend the disclosure obligations of the parties, which is, after all, why they're citing Galadari, why they're relying on Galadari and Lonhro. I mean, what they said about Lonhro yesterday was that you can't, if a document is not within your control, you can't be made to make a polite request or an informal request for the document which is otherwise not within your control.
Mr. McLean, my understanding of the argument that's put against you is that the one thing the court cannot do, either compulsively or by requesting, is to order personal material that is not within the control of the defendant defendant to be delivered up to anybody, a consultant, a solicitor, or the defendant itself. And this material, the private material, that is the device itself, and the non-business related material is not within your control. And I see that in paragraph 32E of Vodafone's skeleton most clearly, which says, however, the mere fact that a personal device contains work-related emails does not mean that the entire device is within the control of the party to the litigation. So that's what they say, and you say, I think, something different.
Well, the question may be fact-sensitive. It may depend on the terms of the contract between the individual and the employer. But we're not.
It may do, Mr. McLean, but this case has been dealt with on the basis that that is irrelevant.
Yes,
namely that anybody who has work-related emails on their phone will be subject to this request under the regime established by the judge.
It's not. That's not accurate. Forgive me, Mark.
Can I just add to that? I mean, in one sense, Mr. Williams' submissions in the Vodafone skeleton go with you quite a long way down the line. It's accepted that if you've got work emails on a personal device, then in principle the work emails are certainly relevant, should be disclosable. But he says that because they're mixed, somehow that means they're no longer within the control of the employer. But it's accepted that if that's true, then of course the court can never look at what are otherwise accepted to be relevant, possibly inculpatory emails and devices. So I think what really divides you is Mr. Williams' subparagraph E. It's when you get mixing on a personal device, which he says is no longer within the control of the employer, to which I understood when you were dismissive of this yesterday. You said, well, that's their choice. It becomes relevant and under control.
One shouldn't get too hung up, as I said, by the fact that these are electronic means of storing documents. The problem would arise in relation, for example, if we could imagine away the world in which these marvelous electronic devices exist, and a party simply, as I said yesterday, had a practice of recording in a notebook all the documents, all the meetings that he conducted on behalf of his employer, and at the same time recorded in that same notebook personal matters, doctor's appointments, or whatever. In my submission, that situation isn't any different from the situation we're concerned with here, and it doesn't provide the court with an insuperable barrier to ordering a party to disclose documents which are otherwise within its control. Now, one can accept, let's assume that one accepts, for the purpose of argument, that the device is not within the control of the employer. Let's assume that, and one can assume that for the purposes of my response. It does not follow that because those work-related documents are, if we can say, stored, or we can also say accessible via the mobile phone, which after all is nothing more than a little handheld computer, it does not follow that because there are other personal, there's other personal information included within that document, that those somehow, the work-related documents are no longer within the control of the employer. That's simply wrong as a matter of analysis. So if, for example, the example I gave yesterday, if a personal device contained 99 emails or SMS messages which were relevant work-related documents, and it contained one personal doctor's appointment, that wouldn't mean that the communications which are work-related, which is after all what the judge's order is getting at, are no longer somehow within the control as defined in the
Mr. McLean, you may be right in all you say, but what is said against you, which I don't think you're really tackling head on and needs to be tackled head on in this case, because the more I think about this case, the more I regret to say significant it could be, is that it is impermissible for the court to order. The court can, the other side say, make an order for disclosure of work-related documents held on somebody's personal device.
Yes.
What the court cannot do is order that the device itself with the work-related emails, or anything that contains personal material is, as a matter of jurisdiction, delivered up to the defendant or its agent, because that would be an impermissible breach of Article 8, and there's no jurisdiction in CPR Part 31 to do that thing. Now, if they're right, then and they say the way round it, from the point of view of preventing cartels getting away with terrible things, is to make the order for delivery up of the work-related emails, and then to go through a convoluted process of enforcing that order, and then they say, well, it may or may not be possible at a later stage to put in place a process by which those emails can be extracted from the mobile phone by third parties when the third party has got legal advice, when the custodian's got legal advice and everything is properly protected. So they don't say it's going to be impossible to get the documents, but they do say that the only way of doing it is to make orders that do not affect personal data, effectively, that do not require delivery up of personal data under Part 31. Now, the question I need an answer to is, do you say that an order for delivery up of the mobile phones can be made under Part 31 in these circumstances?
Yeah, the answer is not to the appellant, because the appellants have not been ordered to procure the delivery up of these devices. All the appellants have been ordered to do is to make a request for provision of the devices for the purposes of conducting a search, to reveal in that source work-related documents. The appellants haven't been ordered to procure the delivery up of the device. Now, it may be different.
You have to accept Lord Diplock's dictum that you can't do something by way of request that you couldn't do by way of order.
Well, I do, and I've been attempting, perhaps not very well, to explain to the court why, say, Lord Diplock's dictum doesn't apply in this case. And it doesn't apply in this case because if you start from the proposition, as I submit is correct, that any work-related message, let's take an SMS message. If there's a work-related message stored on the device or accessible by means of the device, then that document, which is an electronic document, is already within the control of the disclosing party, and he can be compelled to disclose that document. It is simply a matter of practicality as to how the steps are taken in order to render that document already within its control disclosable. This doesn't trespass on anything that Lord Diplock said in Honour.
Well, practicality, I mean, it does if you say that the requesting is okay, but the order for delivery of the mobile phone to an intermediary like the IT consultants would not be possible.
Well, see, it seems to me that the court has the power to order the delivery of a device, which is a mixed source, order the delivery of the device to a third party for the purposes of conducting a reasonable search in relation to those documents. The court has the power to do that.
Why does it have that power?
Because the court has a power if it considers that that is a reasonable thing to do in relation to the search, which ought to be conducted for documents which it's accepted are within the control of a disclosing party. The court must have that power.
And is that whether court must have anything. The court either has a power under the rules or it has an inherent jurisdiction, but it doesn't must have. I mean, I'm sorry, that's not very good English, but I mean, you get my opinion.
I get your lordship's point. 3158.
No, 31.4 first. I mean, it has powers in relation to documents. And the document means anything in which information of any description is recorded. Now, I mean, that, I'm sorry to sort of push the argument in a particular direction, but
No, not at all.
I am very keen to know whether the mobile phone with a work email on it is a document which is the subject of Part 31. I think it's always been held to be so.
Well, we haven't been able to find a case saying that, and I don't think my learned friends have turned up a case which says that either. And it's obviously worth looking at the relevant rules. So if you look at 31.4,
well, I mean, a hard disk of a computer is mentioned in the notes.
yes,
Which a computer database, a computer software.
yeah,
I mean, the hard disk of a computer is a classic piece of computer hardware containing data, which may contain messages, of course.
my lord, I agree. If one seeks to analogize the mobile phone, the closest analogy that one can get in the absence of authority is that, as you say, the hard disk on the computer is like the flash memory on the phone. Now, the flash memory on the phone is essentially a chip which is built into the hardware on the phone, as I understand.
It's a hard disk. It's a hard disk. I mean, for all intents and purposes, it's a different form of smaller hard disk. But the reason I'm holding your nose, if I may respectfully say so,
Yes.
to this fire, Mr. McLean, is that I do not wish, I'm afraid, to a shadow box in this very important piece of litigation. If we're going to say that this order was okay, it must be jurisdictionally okay, and you must persuade us of that. The other side say it is jurisdictionally very much not okay, and anyway, speaking only for myself, I'm not going to give a judgment saying it is, unless I'm quite satisfied on the rules and the law as it currently stands. It is.
Right.
So you can't avoid it by saying, look, it's a lovely mechanism which all works really beautifully, and it's only a precursor to disclosure, and it's all got to be reasonable, and in this case it was all reasonable. I mean, you can assume, anyway, so far as I'm concerned, and that all that is understood. You don't need massive, lengthy argument about how bad cartels are.
No, indeed. In reality, while you can analogize the hard disk on the computer with the microchip in the phone and say, well, that's a document. Reality is, I would submit, that the phone is no more a document than the computer itself is a document. So the phone is a means of accessing documents which are either stored on the chip or accessible via the chip because they're in the cloud. Now, the cloud, in my submission, is not a document. The cloud is a place where electronic documents are stored. And those electronic documents in the cloud can be accessed by virtue of the technology in the phone. That doesn't make the phone a document. It makes the phone a device which is capable of accessing documents. But if it were necessary for the court to hold that the phone or its chip was a document, then the court, in my submission, could so determine. That's not my primary submission. My primary submission is the phone is a means of accessing documents. It's a means of accessing documents which are within the control of the defendants because it contains work-related material. but it also apparently, or one would assume, contains non-work related material, i.e. personal material. Now, what power does the court have to conduct searches in that particular repository? Does the court have power to order the delivery up to a third-party IT person to conduct a search over the device? It's not what was ordered here, but you wish to push my nose to the fire, as opposed to my feet, perhaps, to a question as to whether that is or is not a document which the court can order to be disclosed. And in my submission, it must be able to order such a thing to be disclosed, subject to due account being taken of the necessary privacy. Now, that doesn't arise directly in this case, because the party to whom the letter will be requested, will be passed if the court permits that, can either say yay or nay, or maybe on conditions. But if you put to me a more hard-edged position, can the party be required to deliver up the phone for searching? Then yes, that is the answer. It could be ordered to be delivered up, subject to protections which the court thought were sufficient for the personal information.
So you don't really go to the extreme extent of Mr. Justice Coleman in Yasuda, but you do say that in order to achieve appropriate disclosure of documents, which are the work-related emails, it is appropriate for the court to give directions, and I'm citing part 531.5.8,
Yes.
give directions as to how disclosure is to be given, and in particular what searches are to be undertaken, of where, for what, in respect to which time periods and by whom, and the extent of any search for electronically stored documents. So, in other words, the court is empowered by 31.58 to give directions, proportionate and appropriate directions, complying with Article 8, etc., which would involve requiring third parties to deliver up devices containing personal information.
The way it would work, because what we're concerned with here is the obligations of the defendants to the litigation, the appellants. We're not looking at it through the lens of 31.17 at this stage.
No, but we have to look at it through the lens of the poor old custodian, who's not a party to the litigation, and yet the court is ordering that the defendant procures the delivery up of his device.
Yes. The order which the court would make would be that the defendant use his best endeavours, whatever appropriate phrase the court thought appropriate, to procure the delivery up of the device to a third party for the purposes of conducting the search. Now, it may be that the third party, the custodian, simply says no. It may be that the employer has a contractual right which he can exercise to achieve that.
Well, the worst that happened so far is in BES Commercial, where the defendant was ordered to request the custodians to produce documents relating to its affairs, and use its best endeavours to secure compliance with that request.
Yes, that is an order which the court can make. It's not the only order that the court can make on the basis of the rules and the powers that the court has under the CPR. It's not the only order it can make. And one of the problems, as the court is well aware of, and as the learned judge is well attuned to, is well, what happens in circumstances where you have allegations of cartel-like behaviour, and there's every incentive for the addressee of the request not to produce the goods. And in my submission, the court is not cannot be powerless under the rules of court in terms of the way in which this is expressed. Simply to say, oh well, it's just a matter for the custodian, and we wash our hands of that.
No, but the court's not powerless because it's got 3117.
It has 3117.
And it can impose injunctions if it was wind of the fact that the iPad or phone was about to be tossed into the lake.
Yes.
I mean, obviously the court is not powerless, but it's also not all powerful.
No.
And we know that iPads go missing. We know that from this very case.
We do. So my submission is that under the existing rules of court, under 3158, the court has power to make a direction as far as the defendants are concerned to use their best endeavours to procure the handing over of these devices or the access to the email accounts for the purposes of conducting a search for documents which are within the control of the party making such a request. The court has that power.
Why shouldn't the judge just have made that order? I mean, as I understand, all the submissions for the defendants, but they'll tell me if they're wrong, they all would accept a BES order.
Well, nobody ever suggested to the judge that they were willing to accept a BES order. What they told the judge was, please don't make an order because we've asked our custodians and they have told us that they did not use their personal devices for work-related purposes. That's the information they gave.
Then, this is now.
Well, that is then, this is now. The judge approached it in stages. He wanted to make something. He wanted to make an order, it's clear, that was less powerful, less intrusive than simply compelling these defendants to use their best endeavours to procure the result which we're discussing in this case. He approached it in stages. The first thing to do is to ask these individuals whether they are willing to allow that to occur. And if they are willing to allow that to occur, what, I ask rhetorically, is the problem with that? Now, the letters have not been sent, so we do not know, the court does not know, what response is going to be received to these letters. And in my submission, one gets a strong sense that what these defendants are concerned about is not that the addressees will say no, but that they will say yes. Because if they thought that all the addressees would simply say, not on your life, these phones contain personal details, I'm not handing them over, we wouldn't be arguing about this in my respectful submission. Forgive me, my lord, I think you may be on mute.
You're absolutely right. I'm on mute and I'll pay the fine. I was saying it's all very persuasive, but it is forensic.
It is forensic, my lord, I agree.
And what we're really looking for here is guidance and help on the legal position.
Yes.
And there seems to be a stark legal difference. The defendants say that the court cannot order that devices containing personal information are handed over to consultants or solicitors, in fact, or some of them say that, or to the defendants for the purposes of extracting the documents. All the court can do in the first instance, before enforcement and so on follows, is to make a BES order or make an order for disclosure of those documents against the defendants.
Yes.
And you say, no, the court can go further, and the court can make an order that involves the requests in the first instance, but ultimately, because of Lord Diplock, involves handing over mobile phones and the devices, including those personal materials. Now, the law is, I mean, if you're right, and the law is, and is actually that mobile phones are not documents, which I don't think you're saying.
No.
What you probably are saying is that they wouldn't be regarded as the defendants in the control of the defendants.
They may not be. The problem is it depends on the facts. Now, in our submission, the judge involved getting into a discussion about the particular facts by making the order that he made. Simply ask them if they're willing to hand over these devices. The facts may be, Michael, that the terms of the contract may either expressly or implicitly require the custodians, if an employer is sued, to hand over the devices for searching in order to determine whether those devices contain work-related documents. That's a possibility. Equally, the contract may contain no such express or implicit terms. If the contract contains no such express or implicit terms, then asking or ordering a defendant to use his best endeavours to procure the delivery up of these devices for searching to a third party may not get you very far, because the addressees of the request, which the court has mandated should be conducted, may be met with a response, no, I'm not handing them over, you have no right to. Equally, if the court were to make an order, a BES order, that they procure the disclosure of work-related documents, the question then arises, how is the search to be conducted for those work-related documents? Is it simply over to the custodian? And can the court do nothing else?
Well, that's the problem. I mean, the problem you've got is the custodians are not represented. They have no, obviously they can get legal advice if they want. Yes. They're not represented before this court. And their rights have to be protected by the judge under the Human Rights Act, if nothing else. And the order in BES was that the defendants request the custodians to produce documents relating to the defendant's affairs, and that the defendant use its best endeavours to secure compliance with that request.
Yes.
And that was where it's left. And I think all the defendants say, we'll do that in the first instance and then see. But where the judge overstepped himself here was that he was asking them to request that they hand over personal data. And they say that is too much.
Oh.
And I mean, that's the, you know, why is it not too much when the thing can be done by another route, is the question I'm asking you.
You say, Your Lordship says it can be conducted by another route. It may or may not be capable of being conducted by another route. It is not immediately obvious to me, whereas it may be obvious to the court, but simply saying to an employee, well, hand over your work-related documents that are on a phone may be beyond the technical ability of the employee. Now, you may say, in this case, that's unlikely, given these are senior executives of a
That's a lovely point, Mr. McClaimant. It's not. I mean, of course, you may be right, but the question is using its best endeavours to secure compliance, and they seem content with that. And using the best endeavours to secure compliance means mobile phone companies, who, as you rightly point out, are probably the most technically capable in the world, to use secure compliance with that request. Well, if they came back and said, we don't know how to work our mobile phones, I'm not sure we'd be believing them.
Indeed, and the court would be right to be sceptical about that. But your Lordship in a sense is concerned with a broader question than simply the mobile phone companies. The question you're posing to is more a broader jurisdictional question in relation to mixed sources. And what I'm attempting to submit to the court does indeed have the power, because of 3158, to make an order. And I don't accept, with respect, my position that the learned judge went further than the BES order by simply compelling the defendants to make a request, because the request is capable, in a sense, that's the first part of the BES order, because the response will either be yay or nay. We hope it will be yay, and if it is yay with the consent of the custodians, then in my submission there is not a legal issue or problem with that, because consent in these circumstances deals with all the various hurdles which have been suggested by the defendants in relation to that course. It would be done with consent. It's not compulsory. I mean, your lordships were addressed yesterday by Mr. O'Donoghue on a case about dawn raids. Article 8, in that context, bears no relation to the situation we find ourselves in this case, where the judge has simply mandated a polite request to be made to the custodians. Article 8 does not prevent an employer making a polite request to an employee which may or may not voluntarily be complied with. If that was the law, and it in my submission is not, no authority has been cited to the court to suggest that it is, then commercial life would come to a grinding halt, because employers often make requests to employees which employees may or may not wish to comply with. If they comply with them, there isn't, in my submission, an Article 8 problem. The only issue then arises, well, how do we take steps to ensure that the data, which is of a personal nature, isn't abused? And that is a mechanism which the learned judge provided for in the undertakings which she required the third-party disclosure people to give to the court. Sorry, my lord, you look like you were about to pose a question.
Can I? I'm trying to get my head around the precise difference between you and the defendants. Yes. I think the defendants say, and I think Mr. Williams's paragraph 32 probably encapsulates the sharpest difference between the parties. The defendants say that business documents, which are on a mixed device, are not under the defendant's control because they're held on a personal device, even though they would accept that those business documents could be relevant and inculpatory. Yes. Therefore, they're not under control. If I understand you right, you say that the business documents are under the control of the defendant because the custodian is under the control of the defendant. And so they have control over the business document, though you accept not over personal material held on the device.
Yes.
Rather, you say 3158 is simply the mechanism for the separation of one from the other.
Sorting the wheat from the chaff.
The alternative is to go beyond that and say, because it's mixed, the employee, in the course of his or her business, has chosen to use the personal device for business purposes. So it falls within 31.4 to disclose the document. Yes. That's extreme.
That is an extreme version of the submissions.
But in that is that right on your analysis of how this fits into CPR 31?
Yes. Yes, it is. What the court is not faced, in my submission, with an unanswerable point by a defendant who employs people who use mobile devices for work purposes. It's not faced with an insuperable problem which says, well, it may well be that my employees have been busy using personal purposes, but those are no longer within my control to disclose those pursuant to 31.8. The analysis that the learned judge has in paragraph 52 of the judgment, that's H1 1814, call 1, tab 18, page 203, if we can call that up. The analysis that the learned judge set out shortly there, dealing with the concept of right situation where a party's documents in the hands of a servant or agent. If and insofar as an employee of a company, whoever senior, sends or receives emails or SMS messages in relation to the business of the company, I think it is clear that they're doing so in the course of their employment. Accordingly, the employer has a right to require production by the employee of those documents, including after the termination of the employment. Now, nobody suggested that analysis is incorrect, and indeed, it seems that it is embraced by the defendants. The question is, well, what happens? What can the court do if the evidence is that those documents, which are within the meaning of 31.8, within the control of the defendant, because he's the principal, he's the employer, what happens where those are also mixed in with personal documents? And in my submission, the answer is the court does have the power to make an appropriate order for the purposes of achieving disclosure of those documents. And the question is, what order is appropriate in order to achieve that? In this case, the learned judge thought that the appropriate way to begin was seeking the consent of the individuals.
For that, all you have to establish is that the business document on the email is under the control of the employer.
Yes, that's correct. And it is admitted, it's now admitted, although it was denied, it's admitted that there are such documents. So the only question is, how does the court go about procuring or getting into the possession of the party who has the right to inspect those documents? And the approach which the learned judge took in this case was simply to ask the owners of these personal devices to hand them over for inspection by a third party, so that the documents which are within the control of the defendants can be made available for their possession, and therefore subject to the disclosure under the disclosure order.
If you're right on the interpretation, scope and effect of CPR 31, then the manner in which the judge sought to exercise his power under Article 8 is not jurisdiction, simply how he exercised his discretion.
Exactly. That's why I've been saying all along, this is not...
Well, so what you're really saying is that whatever the niceties of the question of control of computer hard disks or mobile phone disks or mobile phone chips may be, there is actually no jurisdictional impediment to the court providing a method under CPR Part 31.58 to allow disclosable documents that are found, that are known to be in a computer environment to be recovered and disclosed.
Precisely. That is it in a nutshell.
And to test it in a way which takes one away from the cloud and electronic documents altogether, and maybe sheds a little light or not, you're saying, therefore, that if the business and the personal had been mixed by the agent, and let's call it an agent,
yes,
in a ledger or a notebook, then it's not, the mixing does not prevent the business records, remaining business records, which are still in the control of the principal. The mixing has no effect. And that is an important, I think, step in your reasoning. The mixing does not dilute or eradicate the nature of the business record. And if one thinks of it in terms of an old-fashioned paper ledger, you're saying there's nothing wrong with either order being please agent extra business material and redact the rest and send us copies, us being the principal, so that the principal then can disclose that which is in any event in its control, or saying for a variety of reasons, the judge having exercised discretion, that the principal should request that the agent hand over the whole of the ledger for a third party to delete the personal and to produce the pages with the business elements. And that is exactly what you're saying. You say there's therefore in the last example, that's perfectly permissible and it's a mechanism. And that's what, as you said, Mr. McLean, you've been saying all along.
That is what I've been saying, and your ladyship's probably put it more shortly and concisely than I could.
If you're right, Mr. McLean, about that, and then all the arguments from the defendants about Article 8 and the infringement of personal privacy rights and even the GDPR really is a question of discretion for the court.
Yes, it is.
You say that the court is given carte blanche in 3158 to find mechanisms by which disclosure can be given, and obviously it must bear in mind the Human Rights Act and Article 8, GDPR and everything else, but provided it keeps those things properly in mind and exercises discretion responsibly. And you would say, in this case, that's what the judge did, and we should bear with his discretion, even if we might have made a different order, bearing in mind all those things, and after 2 days' argument in the Court of Appeal.
That again is my submission, my lord. This is a classic case of case management where we've cited in our skeleton, and I don't need to cite to your court, to this court, the proposition that in case management cases, the court bends over backwards in order to accommodate a judge's exercise of his discretion unless something has gone very wrong. I'm putting it like that, and in this case it has not. And it's very interesting that when one looks at the submissions which were made to the learned judge by Mr. Hoskins, who took the lead in the argument below, as he has done in this hearing, perhaps if one looks at supplemental bundle volume 2, that's H2 tab 27, so it's tab 27 of the bundle. At page internal 319 or H2 2736, if we could get that up, please, H2 2736. And if we could, I don't know, my eyesight is appalling, if one could blow that up a little bit, if that's possible. Thank you very much. And the court will see, thank you, on internal page 137, I think we've blown it up too much. Can we take it out a little bit? I'm forgiven. Line 15. Line 15, internal on 137. This is Justice Roth. Yes, but if there's no power to do it, insofar as the court has no power to make the order, I can't make the order whether it's desirable or not. That's the end of it. Mr. Hoskins, yes. Insofar as there is a power to do it, then I thought you were saying, well, even though you have the power, it's very intrusive. It's very intrusive, and the individuals would be upset about it. Mr. Hoskins, yes, that is Mr. Justice Roth. I'm saying, how is that different from when the Competition Authority, which, as you say, unquestionably has the power, when it exercises it? No doubt the individual is frequently unhappy. Mr. Hoskins, but my lord, you are to exercise a judgment taking into account all the relevant considerations. Yes, one of the relevant considerations in my submission is an important one, is the effect on privacy. Yes, that clearly is a relevant consideration. Given it is a relevant consideration, it is one that you must take into account, with all due respect. Yes, obviously, the weight you give to it is entirely a matter for you. Now, what we have here in my submission is that the judge did privacy. It's just that the weight which the learned judge gave to it, the appellants don't like. And in my submission, unless the court comes to the conclusion that the consideration that the learned judge gave to the question of privacy was so defective as to vitiate the exercise of his discretion, the answer to that is too bad. That's a matter for the judge, and he has balanced that in his consideration when making the order that he made. And that's the answer to the Article 8 complaint which is made. As far as GDPR is concerned, well, your lordships and your ladyship know that that wasn't even mooted before the learned judge. Now, the appellants say, oh well, that's all McLean's fault because of the way in which this was developed in front of the judge. With respect, that simply won't do. As the Master of the Rolls said, I do have broad shoulders and I'm prepared to accept responsibility where responsibility is due. These appellants, before the learned judge, were represented, at least some of them, by two leading counsel. Mr. Williams was led by Mr. McQuater. Neither of them suggested to the learned judge at that stage that there was a potential GDPR problem. As I've said to the court, the learned judge didn't formulate an order on the hoof then and there. There was further scope for submission, which was taken up by the defendants in order to try and persuade him that he lacked jurisdiction to make the order that he made. We didn't hear anything about GDPR at that stage. The first time GDPR surfaced was in relation to the skeleton argument by Mr. Williams seeking permission to appeal. Now, GDPR point is bad for a whole host of reasons. And unless the court wants me to develop this at length, what I'm going to say is this. When you look at the diffident way in which the oral and written submissions were made about this by Mr. Williams, in his skeleton and orally, it's clear that he's not suggesting that there is some hard-edged point which meant the judge was wrong. He says there are concerns about GDPR. Well, if there are concerns about GDPR, those ought to be alleviated by cooperation between the parties, not by seeking to undermine the order made by a High Court judge in an appeal to the Court of Appeal. Next, as far as GDPR is concerned, the question simply doesn't arise. There is an exemption in the GDPR for compliance with orders made by the court. This is a point raised yesterday by the learned Master of the Rolls. We're here concerned with court orders. In my submission, there is simply no authority properly brought before the court to suggest that that is wrong. Moreover, under Article 6 of the GDPR, if the individuals hand over these devices for the purposes of searching, it'll be done with their consent. So that'll be lawful too. But then arise further questions as to whether the IT provider or the third party who gets hold of these devices is a data controller. In our submission, when you look at the terms of the definition of data controller, the IT people are not data controllers because they do not determine the purpose or the means for which the data processing is conducted. So that they're not controllers. Are they processing data? Well, that's debatable as well, frankly. So, in my
separating out, aren't they? They're doing a qualitative sifting process of business from personal.
That's all.
Whether or not they're controllers or processors.
Yes.
That is being done for the administration of justice under Section 8 or in compliance with the court order.
Exactly.
Exemption.
That's exactly. That's the answer to that. Now.
Well, Mr. McLean, I see you sort of running out of steam a bit, which is uncharacteristic. But I think perhaps it's a good time to take our 10-minute break.
Yes.
If that's satisfactory to you. We'll start again at 5 minutes to 12.
Thank you, my lord.
Thank you.
Thanks, Sarah.
Mark, you're not muted.
Let me just check that Lady Justice Asplin is with us.
Yes, I am.
And Lord Justice Green. Not yet, I think. Lord Justice Green? Ah, sorry. You didn't show up on my list. Lovely. Yes, Mr. Glenn.
My lords and my lady, I'm going to wrap up, not because I've run out of steam, but simply because I've addressed the points I wish to make to the court, subject, of course, to any further questions the court has. But before I do sit down, may I specifically direct your attention to our skeleton arguments, which is in Core 1, tab 15, page 158. So that's bundle H1, 15/9, paragraph 33. I hope the court sees paragraph 33, where we submit, second, the appellants mischaracterised the order as requiring them to take steps to obtain control of documents which they do not otherwise control. Specifically, and we give examples of what they say. So, for example, Deutsche contends the order is flawed because the court actually has no power to order a party to take steps to obtain documents that are not within its control. And similarly, the other defendants, as we set out there, make that submission. And if I could then invite the court to see an example of this, H1/12/21, that's Core Bundle 1, tab 12, page 121, paragraph 45, these are submissions of Orange. For the foregoing reasons, the court did not have jurisdiction to make the direction. Insofar as the direction is an order, the defendants take steps to bring documents within their control so they can be disclosed. It falls foul of the rule in Dubai Aladarim. Now, as I've said to the court, the jurisdiction argument arose following the circulation by EE of the Galadari case. And we had understood that the jurisdictional objection which was being taken to the order the judge made was on the basis that it trespassed on Galadari. And for the reasons that I explained yesterday and sought to explain again this morning, the order does not do that by reason of the mechanism which the learned judge put in place. They do not have control of documents which they do not otherwise have control of, pursuant to Part 31, Rule 8. And that's the answer to that jurisdictional question. The rest then is a matter for the discretion of the judge, and in our respectful submission, his exercise of that discretion is unimpeachable. Now, if the court has any further questions for me, I attempt to answer them. Otherwise, those are my submissions.
Lady Justice Asplin.
No, thank you.
Lord Justice Green. Sorry, thank you very much, Mr. McLean. Now, as for reply, is it intended that each counsel will reply, or is there to be a united front breaking out?
£10 fine for me.
Yes. Mr. Hoskins, you're going first at least, but what's the answer to my question?
Yes, sorry, that was I was on mute when I was giving the answer. We are each going to say something, but we will maintain the focus that we did in opening so as not to trample over the tracks. So it means I will focus on the first issue and the rider question.
And limit to an hour so we can finish by lunchtime. How would that be?
Let's canter through it and see where we get to.
Very good, Mr. Hoskins.
Can I start with the order, please? Bundle H1, tab 17, page 7. It's page 185 in the hard copy. Well trodden, but it is important to it's not just a request for documents. It actually includes a request for access to their personal mobile telephones. In other words, the defendants are ordered to request access to the personal devices of the custodians. In our submission, mobile devices are not themselves documents for the purpose of CPR Part 31. Can we go please to bundle H3, tab 20.5? Meaning of document, 31.4. Document means anything in which information of any description is recorded, which is obviously a broad definition, but it is expanded on in the practice directions 31B. If we can go to page 3, please, of this tab. Rule 31.4 contains a broad definition of document. This extends to electronic documents. And then if we go, I'm so sorry.
Which paragraph are you in the practice direction?
So I'm just reading from the very first paragraph.
Yeah.
It's a broad definition which extends to electronic documents. And then paragraph 5, sub 3. In this practice direction, electronic document means any document held in electronic form. It includes, for example, email and other electronic communications, messages and voicemail. No suggestion that the devices themselves are documents that contain those text messages and voicemail. Word processed documents and databases, and documents stored on portable devices such as memory sticks and mobile phones. So the definition of electronic document, as far as the practice direction is concerned, includes documents stored on mobile phones. But in our submission, it's clear from the note that it's not intended to cover the memory sticks or mobile phones themselves. It's only the documents on those devices which are covered. And
well, Mr. Hoskins, Mr. McLean, despite being pushed by me into a more extreme submission, shunned that extreme submission and said that, at the very least, I think, we didn't need to decide that the mobile phone was a document for the purposes of this case because what he relied upon was 31.58.
well, I think the world's common ground between us on that, but of course that then becomes an important point because when we come to look at the power of the court, jurisdiction, etc., I've shown you what the order covers. It's not limited to documents on the phone. It's a request for access to the device itself.
Yeah, it's a request to hand over the device for the purpose of giving disclosure of documents stored thereon.
Yes.
What's wrong with that?
Well, I'll come to that. That's the purpose of mine.
If it's a notebook and it contains a note that says, I'm going to the dentist, 1, 2, I'm going to start a cartel, 2, why is the notebook not disclosable for the purpose of looking to see if there's a note to that effect?
Because one has to distinguish between the nature of the document or the entry in the notebook. So let's just clarify what the position is as far as we are concerned. Documents, let me call them business documents for shorthand, on a personal mobile phone are within the control of the employer. 2, personal documents on a mobile phone or in a notebook are not within the control of an employer. And 3, the phone itself, the device, is not within the control of the employer. So the court certainly has jurisdiction to order, to require the employer or indeed the custodian itself under a third-party disclosure order to order delivery up of business documents. But our submission, as you know, is that it does not have jurisdiction to order the delivery up of personal documents or the device on which personal documents. So we're not saying that just because there is a mixture of business and personal documents, the court can do nothing. In the case of a mixture, the court always has jurisdiction to seek disclosure of the business documents. So I'll come on to the ways in which it can and should do that. I hope that clarifies our position. Now, if Phones for You is right, the court can order personal devices to be reviewed wholesale. That's the nature of the submission that's made to you. And I don't need to take long to point out that that has very serious privacy issues. And those privacy issues are heightened by the fact that, again, according to Phones for You, an order for review can be made without hearing the third party. That is the nature of Phones for You's submission. An order can be made for wholesale review of a device without hearing the third party concerned. Now, Mr. McLean for Phones for You says, well, what's wrong with requiring the defendants to make a voluntary request of its custodians? That was a refrain he came back to often. Well, there's not a problem here. It's a voluntary request. The custodians can choose whether to comply or not. Well, the problem is House of Lords authority. It's Lonro and Shell.
Well, that House of Lords authority didn't take into account 31.58, which didn't exist in those days, did it? Was there an equivalent provision in CPR Part 24? RSC 24.
I'd need to check. I don't know the answer off the top of my head, and I'm sorry for that. I should know the answer.
Even if there was, Mr. Hoskins, that's not what Lord Diplock was talking about.
Yes, I'll come on to that. So I refer to Lonro and Shell for the principle that where a court does not have power to make a particular disclosure order, it cannot circumvent that lack of power by instead making an order requiring a voluntary request for access to documents to be made. That's the principle I take from Lonro. That principle, I say, applies as much as it did under the rules of the Supreme Court as it should apply under the CPR. And I'll come on to 31.58. It's clearly very important. So in our submission, in order to determine whether the judge had jurisdiction or power to make the order which is the subject of this appeal, one must therefore ask whether he would have had power to make such an order in mandatory terms. And in our submission, the court would not have power to make an order against Telefónica's employees, requiring them to deliver up their personal information to Telefónica or to a third party acting on behalf of Telefónica, or indeed to an independent solicitor.
No, but they didn't make that order. The question, the comparison is with an order against the defendant, if you're right about Lonro, order against the defendant to require them to deliver up their employees' mobile phones.
And my lord, the submission is the same. If the order can be made against the employees directly to deliver up their personal information for review, it must follow that the court cannot have power to order deliver up of a device wholesale or the personal information of the employees to be reviewed. It must follow a fortiori. If it's right, you can't make the order against the employees themselves. You can't make the order against the employer. Now, if it's right, and that position, of course, is made worse again, you have to consider the position, even if the court did have power to make the order up for delivery up of a device containing personal information or the personal information itself, in our submission, it certainly couldn't do so without hearing the third parties themselves, either as a result of Article 8 or as requirements of fair procedure. And if it's right that the court doesn't have power to make those orders, either against the employer or against the employee, it follows from Lonro and Shell that you first ask yourself, could a mandatory order be made in these terms? And if it couldn't, you can't get round it by saying, well, it's just a request, so it's not a problem.
Do you think that under 3170 make a third party was in possession of, let's assume, relevant and inculpatory communications?
No, because there the employee would be a party and would be heard.
Would always have a procedure under an order made against the defendant whereby any custodian who considered him or herself to be prejudiced had a right to apply to the court. I mean, maybe that's just a matter of mechanism being built into an order to achieve sufficient protection.
Well, which wasn't done in this case. So I have two submissions. One is no power to make the order, and second defect is no power to make the order because you don't hear the employees. So the suggestion you've made to me, my lord, would palliate the second concern, but would not meet the first concern. And of course, that was not the position here. So then one comes to the way in which Once For You tries to get round these jurisdictional problems is Rule 31.5 sub 8. And a submission on that is simple. 31.58 cannot give the court the power to do something it would not otherwise have the power to do. Let me put it this way. It is a facilitating provision, not a jurisdictional provision. Just as one cannot get round a lack of power to make a particular disclosure order by turning it into a voluntary request, one cannot get round a fundamental lack of power to make a disclosure order by praying in aid 31.58, which is a rule which is intended to allow the court to give effect to its power, to the scope of its disclosure powers, but is not itself a definition of those powers. It's not a cure-all for obvious reasons. And particularly, again, one sees the problem in this case. If 31.58 had the meaning, the effect that Once For You contends, then the court could make these orders without hearing the third parties who are concerned. And they'd simply say, well, we're just doing it because this is a mere procedural provision. Clearly, if one construes the CPR, construes that rule in its context, cannot have that power in force. It is not a jurisdictional provision. So, of course, that leads us to the flip side. Well, if that's what the court doesn't have power to do, what does it have power to do? Now, there is no lacuna in the CPR for dealing with cases such as this. And another way of looking at this, and I don't trample too much on Mr. O'Donoghue's toes here, but from an Article 8 perspective, there are far less intrusive orders that the court could and should have made in order to comply with Article 8. So what are the possibilities? Well, we've been through them, particularly in the exchange with Mr. Scanlon, the Master of the Rolls. The court has jurisdiction to make an order for specific disclosure under CPR 31.12 against Telefonica, requiring it to disclose documents relating to the case held by its employees. But of course, that order would only relate to business documents. It could not extend to personal documents or the device itself where there are mixed documents. Secondly, the court has jurisdiction.
Assume that such an order was made, and the judge then give directions under 31.58 along the lines that he did, in order to ensure that that order for disclosure can be achieved.
Sorry, make an order that there be reviewed by third parties.
Yes, so the judge makes the order in the terms that you've described, in order to facilitate that, and the judge not make an order under 31.58 similar to the order that he made, which is reflected in paragraph 15 of the order.
Certainly not without hearing the employees concerned.
So that
to do so would be a breach of Article 8 or fair procedure.
So, but in principle, it could, provided a proper procedure is applied.
As long as that. No, I'd say it couldn't even in that circumstance, because for the point I made at the start, which is you have to distinguish between three categories of potential documents and the device itself. So the court can make an order requiring, against Telefonica, requiring it to disclose documents within its control. Documents within its control are business documents. The personal documents and or the personal mobile phone are not within the control of Telefonica. The second type of order that could be made would be a BES type order. Again, that would be made against Telefonica. And that would request an employee to produce business documents to the employer, and would require the employer to use its best endeavours to secure the employee's compliance with such a request. Now, under both of those types of orders, compliance could be achieved without Telefonica's employees necessarily being required to provide access to the whole of their personal information. Compliance with those orders does not necessarily require access to the personal information. And that is why they are less intrusive, and that is why the court has power to make those orders. Now, of course, that leads to the issue of what if you have a recalcitrant employee, which is really the thrust of the question that Lord Green just put to me. Now, in that circumstance, Telefonica might be obliged to bring an action against the employee to enforce its rights, as we've seen from the various cases. Many of them are principal against agent cases. That is an action that can be brought. But the important thing is that in such a circumstance, where an action is brought by an employer against an employee to obtain access to documents within the employer's control, i.e. business documents, the employee as a party could make submissions about the protection of its own privacy rights. That's the fundamental difference, and that's what one doesn't find in the order that Mr. Justice Roth made. And the third possibility, in order to obtain access to the necessary documents, is of course the third-party disclosure order. And again, that would not necessarily require the employee to provide access to the whole of their personal information. And the employee would obviously have the chance to make submissions. And if the court were against me on the fact that in relation to any of those heads, that the court could use 31.58 to conduct some sort of review of the whole suite of documents, there is always that point. Yes, but only having heard the third party first. So I say it doesn't have the right to make the order for the review, but if it does, only if it's heard the employees first. And of course, an application for third-party disclosure against an employee could be made by a claimant either as a first or a last resort. It doesn't have to be a convoluted process where one goes down, for example, the BES route first and then sees what happens. It's always open to a claimant such as Phones for You to start with a third-party disclosure order if it wishes to. It's up to the claimant as a choice of routes to pursue. Well, Lords, my lady, that's all I was going to say on the jurisdiction of PowerPoint. Hopefully that frames our arguments and packages them in a clear way. The final submission I wanted to make related to the rider point. Unless you had any questions on the jurisdiction or PowerPoint before I move on to that.
Yeah, thank you.
So on the rider point, Phones for You made two main points. First of all, Phones for You submitted that the judge just wanted the request to custodians to be in neutral terms. 2 points in relation to that. Accurately describing the nature of the request does constitute neutral terms. If the request itself describes compliance as voluntary, which of course is accurate, that is neutral. Secondly, of course, if one obfuscates the nature of the request by not indicating its true voluntary nature, that is not a neutral term. The whole purpose of not explaining the basis of the request, the nature of the request, is to seek to induce the custodian to comply without realizing that he or she has a choice. So the prevention of the letter, the request, making it clear said that under the order, if, having received the request, the custodian then asks the defendant if he or she is obliged to comply with the request. According to Bourne's view, under the order, the defendant could at that stage explain that compliance was voluntary. Well, again, if it's open to a defendant to respond to a question in those terms when it is asked the direct question, the only reason for failing to reflect the true nature of the request in the letter making the request would be to try to induce the custodian to comply without realising that he or she had a choice. It's clearly an unacceptable way to deal with the nature of the request. My Lord, my Lady, unless you have any further questions, those are my submissions in reply.
Lady Justice Asplin or Justice Green?
Can I just ask you one thing about the rider? If the order, if the letter which was to be sent, the letter of request, had said in terms to the custodian, one, you can refuse, two, you can apply to court to make representations, three, if you refuse, the court might issue an injunction against you and or order disclosure against you personally. Would that have sufficed, in your view? In other words, utterly transparent about the rights, but also the risk of adverse consequences if the custodian doesn't comply.
Not on my, not, sorry.
Would you accept that?
No, not on the pure jurisdiction point. I've put the point in two ways. One is a pure jurisdiction point, which is based on Lonro, that you can't do something voluntarily that you don't have jurisdiction to do. And my second point is there is a lack of power to make a demand or a request, or even a voluntary request of a third party without giving themselves the chance to be heard. Now, again, the point you've made to me would palliate the second point, but wouldn't meet my first point.
Mr. McLean. Do we have Mr. O'Donoghue next?
My Lord, yes.
Yes. Sorry, forgive me. I'm getting you confused. I don't really confuse you, be assured.
My Lord, it's a good comparison, if I may say so. I've been called worse.
Mr. O'Donoghue.
My Lord, my Lady, picking up Mr. Hoskin's last point, the judge's ruling from our perspective is concerning, since in our case it runs a very substantial risk that the custodians would feel compelled, or at least under some pressure, to hand over all of their personal emails and devices to a set of overseas IT consultants working for the defendants, who the custodians have no relationship with, or indeed may never have heard of. Now, I would suggest that that is obviously problematic, and that most people, including those who have nothing to hide, would find it concerning, perhaps deeply so. Mr. McLean valiantly, through the erudition of Latin, tried to say that the judge's direction on not being able to tell the custodians that the order was voluntary was intended to achieve what he described as neutrality. But elegant though those efforts were, they actually served to underscore the problem with the judge's ruling. An in-house lawyer should not need a lesson in Latin grammar or metaphysics to decipher the true meaning and effect of a High Court order or direction. It should be crystal clear. So the judge's ruling in my submission is obviously problematic. Now, the important legal and practical question is what should have been done in a way to make such an order compliant, in particular with Article 8 proportionality. This is self-evidently an important question. As Mr. McLean conceded yesterday, as my Lord the Master of the Rolls put to him yesterday and today, these types of issues could in principle arise in any case governed by CPR 31, in which there is a suggestion that relevant and material documents might be located in personal emails and devices. This is potentially an enormous number of cases. Now, let me take off the table straight away two straw men, or what my Lord the Master of the Rolls called tendentious points. No one is saying that you could engage in serious wrongdoing in the sphere of personal communications, and that all such documents would be off limit. But nor I think, or I hope, is anyone saying that just because some documents relevant to an issue in civil litigation might be located on personal emails or devices, the start and end point is that all of those emails and devices must immediately be handed over by the custodian to a third-party agent of one of the inter-parties parties. The question is how the balance is to be struck, and what mechanisms and procedures are necessary
at a minimum, to make the process Article 8 compliant and proportionate. In striking any balance, it is important to be clear about the extent and importance of personal communications in terms of usage, since that conditions how the balance is to be struck. There may be extreme cases where there is evidence that particular individuals deliberately took all or at least the critical part of their discussions offline into dedicated non-work emails or devices intended to conceal what was going on. But no one is seriously suggesting that we're in this territory here. Instead, we are concerned with a normal situation in which there is a possibility that a small number of work-related emails might have been sent to or from or copied to private emails or devices. In other words, we're concerned with email accounts or devices that are only or overwhelmingly private in nature and are highly probable to contain quite sensitive personal information on the email or device in question in relation to the holder and his or her family and friends. The balance as a starting point to be struck in such cases is obvious. The privacy concerns in that situation are acute, and an Article 8 compliant mechanism and set of procedures and protections must be put in place to reflect that circumstance while bearing in mind the interests of the requesting party in seeking proportionate disclosure. So what are these necessary minimum guarantees and procedures? Let me start with an easy case. There may well be custodians who are intensely relaxed about privacy and are happy to have their personal emails and devices perused to see if they contain relevant and material documents for litigation. Such individuals are likely to be rare in practice, as indeed this case shows, with the exception of the EE Defendants. In such a case, DT obviously accepts that the Article 8 proportionality considerations are less acute, since the person providing consent, and we assume for these purposes that the consent is informed, and not as in this case, potentially the result of considerable uncertainty. The main issues in such a case are likely to be, first, if the custodian feels he needs the assistance of legal or technical nature to review his or her emails, can they choose their own independent assistance? In my submission, in principle, yes, of course, certainly in the first instance, as it is a voluntary exercise. There will, in such a case, in my submission, need to be a mechanism for protecting the confidentiality of documents that implicate both private and work-related information, if the documents are to be used in litigation. This can be addressed. Confidentiality rings, for example, are quite normal in competition and IP cases. And finally, since the documents may contain private information, and the privacy rights belong to the individual and not his or her employer, it will be important to have a mechanism whereby the custodian in question could be heard in advance by the court if decisions are made affecting his or her privacy in that case. So that's the easy case. The harder case, of course, is where the custodian feels uncomfortable about giving voluntary unfettered access to his or her personal emails and devices, and what procedures and mechanisms ought to apply in that case. Each case will, of course, differ to some extent, but some general guidance on Article 8 compliant procedures can be envisaged. First, it will, in my submission, be essential to establish what documents or document categories the employer does or does not control. This is a threshold jurisdictional question. Without at least some control, the application does not even get off the ground, at least qua the employer or principal. The court's order should make clear that disclosure is being ordered in relation to documents under the control of the party. Second, assuming there is control over at least some potential documents and a mandatory order is made, the next issue is how the search should be conducted, where there is some mixing of personal and work-related documents. In my submission, in the case where the documents prima facie appear exclusively or overwhelmingly private in nature, the custodian, certainly in the first instance, should be the one who undertakes the document sift. If they want to retain legal, technical, or other independent assistance for this purpose, they should, of course, be entitled to do so, albeit there may be important practical questions as to who pays for this. This is the standard order made for many decades now in the case of principal agency cases. The agent conducts the sift in the first instance, and it is a fortiori the correct order to be made in a case such as the present, where the documents are only or overwhelmingly private in nature. The custodian would obviously have to explain what he or she did in terms of the sift, raised by Lord Justice Green yesterday, twice to Mr. Scandal and myself. What happens if one or other parties is not happy with the SIFT done by the custodian and thinks that something relevant material has not been disclosed? In my submission, the answer is clear. CPR 31 has a series of iterative options that can be ratcheted up as the case may be. The first would be to understand that if the employer principal has control over certain documents, what legal and practical rights does the employer principal have to enforce such control? This would obviously involve looking at the contractual rights in the first instance to see if there is an easy practical way for control to be exercised. In most cases, there's likely to be such a mechanism, but you may get complex cross-border cases where, as a matter of the law of the contract, there are some restrictions on disclosure. For example, the court may recall that in Longrow, disclosure by the local subsidiaries would have been a criminal offence under the laws of their respective domiciles. The court will probably also be aware that cases have come before the English courts on the impact of the French blocking statute on disclosure. And in DT's case at least, there are cross-border issues, since all of our custodians are based overseas in different countries. And one of our custodians has actually left the company, so there may be issues as to post-employment rights and survivorship as a matter of contract law. Those issues, as Mr. McLean said yesterday, have not played out in evidence in these proceedings so far, since Fonsu did not actually make an application that would raise these points. Now, if there are significant...
Can I be nasty and just change the permutation of fact? Let's assume that the court is persuaded that there's a real risk of dissipation or destruction of documents. Then what are the court's powers? Can the court then take a more extreme approach?
Well, no, if the facts merited such an approach, then as Mr. Hoskins says, one option is to cut to the quick and say, I will consent or issue a third-party disclosure application as a first step because of that risk. But of course, it would have to be evidenced.
Let's assume it is evidence. You could order a 3117, or you could make an order along the lines that the judge did, which put the sifting process into the hands of a third party to minimise the risk of destruction or dissipation. Would that be equivalent?
Well, perhaps, but of course, the independent protection for the privacy rights of the custodian would be an important
Understood.
separate point.
It is a separate one, but understood. Thank you.
Now, my lords, my lady, if there are significant legal or practical problems with the employer principal enforcing a legal right to access documents under its control for purposes of English civil procedure law, it would always remain open to a party seeking access, either to issue a specific disclosure application, or as I indicated to Lord Justice Green, more likely a third-party disclosure application against the custodian. And then finally, if for some reason these procedures are not practically effective and the documents are not disclosed, then this would be a matter for the trial judge to consider when assessing the facts of trial. There is always a possibility that inferences could be drawn at trial, and indeed in many ways, this shows the dangers for any party playing fast and loose. The court may be far less inclined to exculpate faced with silence or obfuscation in relation to matters falling within the sphere of that party or the custodian. Now, to come back to Lord Justice Green's questions yesterday, and again today, is there not a concern that that approach could lead to something relevant and material not being disclosed? In my submission, there are two responses to this. First, because of the iterative approach I've outlined, and disclosure by other parties. In this case, of course, there are 8 defendants in total, so there's an interaction between the different disclosure exercise. It would be an extremely risky strategy indeed for a party to adopt that approach. The second response is that that risk is in a sense inherent in an exercise of proportionate disclosure based on a reasonable search. It is obviously not an objective, but it is a possibility in potentially any case. If I can just leave the court with one final reference, it's in H3 tab 26. It's the Nishia case. It's H3 tab 26, and it's paragraphs 50 to 52. 50 to 52. in relation, my lord, to the point I've just mentioned, that proportionality simply requires a reasonable search. So this is Lord Justice Jacobs, and he says 51 or 50, perfect justice in one sense involves the tribunal examining every conceivable aspect of a dispute. But a system which sought such perfect justice in every case would actually defeat justice. So a compromise is made. One makes do with a lesser procedure, even though it may result in the justice being rougher. Putting it another way, better justice is achieved by risking a little bit of injustice. And then the end of 52. But the rules now sacrifice the perfect justice solution for the more pragmatic standard disclosure and reasonable search rules, even though in rare instances the right result may not be achieved. In the vast majority of instances it will be, or cheaply so. So the point Lord Justice Green raised is of course perfectly fair, and I'm not suggesting for a minute it is an objective, but it is a fact of life in the real world where the template is proportional disclosure based on a reasonable search. That some stones may be left unturned, but that is the nature of the system. It's not an inherent defect. So, my lords, my ladies, those are my submissions. One final point I want to pick up on very quickly, if I may. Mr. McLean made the point about the Vinci case, saying, well, it has nothing to do with this case. It obviously doesn't concern inter-parties litigation, which is a point I made yesterday, but it is directly relevant in the following sense. In that case, the issue was that business emails were searched en masse, and the privilege information had been seized. And in relation to those two categories, the European Court of Human Rights says, well, the persons whose interests are affected has to have effective judicial review available against individual documents falling into those categories. Now, in my submission, if one extrapolates from that and says, imagine a situation where the Competition Authority, as a matter of course, sees the entirety of the personal email accounts and devices of the custodians in the context of that dawn raid, then of course the principles which the court found to be a violation of Article 8 in that case would be a fortiori in the case of the personal document. The simple point is that the person who in this case has privacy rights which are affected must be able, before, during and after the seizures, to be able to ventilate and vindicate those rights. The problem with this order is that it contains no facility whatsoever whereby the important privacy rights of the custodians can be ventilated in any way. That is a manifest defect. It is simply silent, lacking in that regard.
Thank you. Any points for Mr. O'Donoghue? Move straight on to Mr. Williams, please.
Yes, my lords, my lady. As you heard in opening, my client's main concerns about the order arose under the GDPR, and I indicated in opening that we would accept a reformulation of the mechanism, as I indicated in opening, which would broadly resolve those concerns. But the questions of jurisdiction are obviously prior to those issues, and the court's going to have to determine the question of jurisdiction, even if there is a route through the GDPR issues. Mr. Hoskins has addressed that, and I'm not going to go back over that ground. I do just want to clarify one aspect of my skeleton argument, which was raised in argument with Mr. McLean. One of Lord Justice Green's questions.
Which paragraph is it, Mr. Williams?
It was paragraph 32, I believe. It was the paragraph with the various subparagraphs.
Yes.
And one of Lord Justice Green's questions to Mr. McLean suggests that he may read my skeleton as saying that work-related material ceases to be available to the employer if it's mixed with personal material. And that isn't what my skeleton was saying, at least it's not what it was intended to say. The skeleton is saying that there is no control of the whole personal device, and the fact that the personal device contains a mixture of work and personal material doesn't bring the whole device within the control of the employer. So that was as far as the submission went, and I think it's the same thing that Mr. Hoskins is saying. So dealing then briefly with the GDPR, Phone's View has maintained the criticism that this wasn't raised below. I'm not going to labour that. given you the transcript references. Our point is simply that we weren't given the opportunity to consider the mechanism which the judge adopted, and in my submission that is clear from the transcript. Mr. McLean has said we could have dealt with it in follow-up submissions. In fact, we got a strict email from the judge inviting submissions on Galadari and BES to be no longer than 3 pages, 1.5 spaced and size 12 font. So that wasn't an opportunity for us to sneak in the submissions I made yesterday on the GDPR, even if those concerns had crystallised at that stage. So then dealing then briefly with GDPR, as I've indicated, the suggestion or the proposal made by the Master of the Rolls in argument does appear to be a solution to, broadly speaking, to be a solution to the concerns we've raised. So some questions remain. For example, I explained the slight difficulties in relation to the provisions under transparency under Article 14, but it is in my submission far easier to see a route through if a solicitor is introduced into the order in place of an IT consultant, given that the focus of that provision is on the administration of justice and a solicitor would be an officer of the court. GDPR, this is a question of compliance with a mandatory law which applies to the controller of data, whether that's Vodafone, whether that's the IT consultant. And in my respectful submission, Mr. McLean didn't really take the point seriously. He said that these issues could be resolved by cooperation between the parties, but of course, if these are mandatory legal provisions and they're concerned with the interests of third parties, then it's not an inter partes matter. And Mr. McLean's representations didn't really give us much encouragement that Phones for You takes compliance with those obligations as seriously as we do. In terms of the substantive points, he said that there's an exception for compliance with an order, but he didn't refer to any specific provision. I took you through the specific provisions yesterday. There isn't an exception or an exemption in those terms. There is a provision which relates to legal obligations, but one then has to ask legal obligation on whom and on what basis. And there isn't a legal obligation on the IT consultant under the terms of the judge's order. And in our submission, that provision is not engaged. He continued to say that consent is an answer to everything, but he didn't address either of the points I made yesterday. That is to say, the fact that the consent is not compliant with the definition of consent under the terms of the GDPR. It's not informed, it's not freely given, and doesn't involve an exercise of real choice. And moreover, even if there were consent from the custodian, there is no consent from all of the other data subjects, all of the other friends, family and contacts on the device. And finally, he didn't address my last point, which was that if there are mistakes in the process, that could lead to the transmission of personal information to Vodafone, which could lead to processing of that personal information by Vodafone. And that is a real issue, my lords. As I said in opening, the safeguards are much clearer if the task is carried out in the ordinary way by professional solicitors who are carrying out the sort of disclosure review which is part of their ordinary functions in litigation. So I'm not suggesting one can't have an argument about the scope of those provisions and whether they might be stretched to cover the role of an IT consultant. Plainly one could have an argument, but in my submission that is not a good basis on which to impose this sort of mechanism and to introduce the risks that those carrying out the performance of the order may thereby infringe mandatory laws. If one's going to put this mechanism in place, there needs to be a solid basis for it in the relevant regulations. So those are the submissions I wanted to make.
Thank you, Mr. Williams. Any points for Mr. Williams? No, in which case we move finally to Mr. Scannell.
Good afternoon, my lords, my lady. My lady, Lady Justice Asplin and my Lord Justice Green asked Mr. McLean whether his argument amounted to saying that his lordship's order was simply a case management decision relating to work documents which are deemed to be within the control of the appellants, and he agreed that was his argument. I do not accept that argument works. Let's leave aside for a moment the civil procedure rules and ask this question. What is the nature of the control that the appellants are deemed to have over the work-related documents in the possession of the disclosure custodians? It derives from their status as a principal, and in Orange's case, we've accepted for the limited purposes of this appeal that it is a principal within the meaning of English law. What exactly is a principal entitled to do in respect of the documents that he controls? He is entitled to request his agent to deliver up his work-related documents that arise from the course and conduct of the agency relationship. The principal cannot ask for more. A principal has no right whatever to ask his agent to deliver up his personal documents, even to an independent third party. If the principal wanted to do that, wanted that to happen, he would have to go to court to get an order to that effect. And no doubt the agent in those circumstances would raise human rights arguments and any other arguments that the agent wished to raise. So in the language of Lord Diplock, the principal has no presently enforceable right to ask for the delivery of anything but the agency-related documents. And Lord Diplock was very clear. Without a presently enforceable right, there is no control over the documents. Now, the control that the principal has, but no more control than that, gets plugged into CPR Rule 3181. We fully accept that there is a power to order the appellants to request the delivery up of the work-related agency documents within the control of the disclosure custodians. But the court cannot make an order that the disclosure custodians deliver up their personal documents, because that goes beyond the control that the appellants enjoy. And it does not matter whether the principal is asked to deliver those documents up to an IT consultant or to a firm of solicitors or to any other third party. My learned friend, Mr. McLean, takes the Galadari case as authority for the proposition that it is impermissible to order a party to take steps to assume control over documents. And indeed it is. But insofar as my learned friend suggests that other orders for disclosure can be made in respect of documents not within the control of a party or a third party, if one is considering CPR 3117, such as a discretionary order, for example, that the documents be given over to a third party, that submission is simply wrong. Galadari is authority for a much simpler, much more basic proposition that there can be no order for disclosure in respect of documents not within the control of a party, whether that be an order that it takes steps to assume control or any other order. As to the position when documents are deemed to be within the control of a party, but are contained within a larger database of documents which are not within that party's control, the same principles apply, and that is critically important to the jurisdiction question. I fully accept, and Mr. Hoskins and the other appellants, as I understand them, fully accept that a Category 1 order in respect of the documents within their control. I used the nomenclature used by the Master of the Rolls yesterday for Category 1. That's a CPR 3112 type order, or a best commercial order if one prefers, or a Category 2 order, which is the third-party disclosure order, can be made in respect of personal documents. That just leaves one question. What, if any, is the role of an IT consultant or an independent firm of solicitors? Can there be any role at all? The answer to that question is yes, there can. I would accept that somebody other than the disclosure custodian may have a role on a Category 1 or a Category 2 order, but the core question for the court is this: when there is a consultant or for a firm of solicitors, on whose behalf is that law firm working for the IT consultant? And the answer must be that if, for example, one has obtained an order for the delivery of the disclosure custodians work documents under the BESS commercial electricity line, the IT consultant or the firm of solicitors must be acting on behalf of the disclosure custodian, because the disclosure there is otherwise an intrusion into the jurisdiction problem that we've identified in this case. Now, the problem with the judge's order is that somebody other than the servant or agent of the disclosure custodian is conducting the review of the personal documents of the disclosure custodian. The disclosure custodians have therefore been ordered to relinquish control over their personal documents without having had any say in that matter. That, we say, is beyond the jurisdiction of the court. So the point is that if there is to be any role for an IT consultant or a firm of solicitors, it must be absolutely clear that it cannot be the servant or agent of anyone but the disclosure custodian. Because in the first instance, it's for the disclosure custodian to look at his own documents, to find the work-related documents within them, and to hand those over as appropriate to the principal. I have no further submissions. I'm afraid you're muted.
I'm sorry, another fine. Yes, Lord Justice Green, you looked as if you wanted to say something?
Yes, I'd just like to ask Mr. Scannell about the judge's analysis of the duty on the custodian, which he addresses in paragraphs 52 to 54 in the light of the Fair Start case. I think your submission rests upon the assumption that the defendant can't compel the employee to deliver up business documents or hand over a device. The judge relied upon Fair Start, and I suppose BES is to the same effect, but that the custodian would be under a duty as the former agent of the principal to permit access to relevant emails, initially by an independent IT person. So is it right to say that the defendant doesn't, that does reflect upon the ability of the defendant to compel its employee or former employee to provide access or delivery up?
My Lord, there is no doubt that the appellants are entitled as principals to request that their disclosure custodians deliver up their work-related documents. That is their presently enforceable right as a principal against the agent. It is then for the agent, in this case the disclosure custodians, to interrogate their own systems, not to hand over their personal documents, but to interrogate their own systems. If a problem arises in that respect, then of course, it is open to the disclosure custodians to appoint solicitors who are instructed by the disclosure custodians to assist them in that task. But what cannot, under any circumstances, happen is a situation such as has happened in this case, where the entire raft of personal documents departs the possession of the agent and is interrogated by a third party, whether that is a third party which is the servant or agent of the appellants or an independent third party. And for the avoidance of doubt, the IT consultants in this case are the servants or agents, at least in Orange's case, of Orange. But that is beside the point in many respects. That what is important is that they are not the servants or agents of the disclosure custodians.
Now, you said that you rest your case on a request. Doesn't the fact that the agent is under a duty mean that it wouldn't necessarily be inappropriate? I mean, the judge might never want to go down this route, but for the employer to require the employee to provide access to the disclosure.
No, I don't. I don't think that is a problem. That the power that the presently enforceable right of the principal is a right to request the delivery up of the documents. That's an
Why is it
enforceable.
only to request? Why? Just following the logic through of Fair Start, which refers to the former CEO as having a duty, not just a right to decide whether or not he wished to, but a duty, which was not said to be dependent upon the contract of employment. I'm really just perhaps cavilling with the word request. I'm not saying that in every case a judge would necessarily make such an order. It may be disproportionate, for example. It may be many reasons why they wouldn't do that. But is it necessarily limited to a request?
It is insofar as the presently enforceable right enjoyed by the principal is a right to request the documents. And of course, when I say request, I'm referring also to an obligation. It's not just a right on the part of the principal. There is also an obligation on the part of the agent to deliver up those documents upon request. I do accept that.
Okay.
But all the principal can ever ask for are the work-related documents in the agent's control. There's never any right to ask for something beyond that. And critically, it is for the agent to interrogate his own documents and to deliver up those documents which are responsive and within the four walls of the principal's right to demand the delivery of the documents.
Thank you very much.
Good. Well, thanks, everybody. Unless anybody thinks they have anything more to say, we're very grateful for the submissions that have been made by all counsel and the help of their solicitors in a very efficiently conducted hearing, if I may say so. We will, it may not surprise you, take time to consider judgments. We'll hand them down in the usual COVID way. But when you get the drafts, please let us have any typographical changes you suggest. Please agree an order and disposition of costs. And if you can't agree any of that, then the submissions that you make must be in writing, and you can agree an exchange regime. And if you're unable even to agree that, we'll reluctantly direct one. But many thanks to you all, and that concludes these proceedings. Thank you.